Good afternoon, everyone. We are convening the Committee on Consumer Protection and Commerce. It is Tuesday, February 11th, 2025 at 2 o'clock p.m. in conference room 329. Just some housekeeping measures first. We will in order to allow as many people to testify as possible, there will be a 2-minute time limit per testifier. For those on Zoom, please keep yourself muted and your video off while waiting to testify and after your testimony is complete. The Zoom chat function will allow you to chat with the technical staff only. Please use the chat only for technical issues or to alert the technical staff that you have reconnected. If you are disconnected unexpectedly, you may attempt to rejoin the meeting. If disconnected while presenting testimony, you may be allowed to continue if time permits. Please note the House is not responsible for any bad internet connections on the testifier's end. In the event of a network failure, it may be necessary to reschedule the hearing or schedule a meeting for decision-making. In that case, an appropriate notice will be posted. Please avoid using any trademarked or copyrighted images. Please refrain from profanity or uncivil behavior. Such behavior may be grounds for removal from the hearing without the ability to rejoin. All right, I'll be handing it over to my Vice Chair for testimony.
Thank you, Chair. So first on the agenda, we have House Bill 496, House Draft 1, relating to Mamaki tea. And first up, we have Department of Agriculture in support. Next, we have, Department of Ag Measurement and Standards Branch on Zoom. Go ahead.
Hello, Chair, Vice Chair. Someone was supposed to be there from the department to stand on a written testimony. I just thank the committee for looking at our testimony, and I'm here and available to answer any questions on Zoom.
Okay. Thank you. Next, we have Hawaii Farm Bureau in support.
Good afternoon, Vice Chair, Chair, members of the committee. Brian Miyamoto here on behalf of the Hawaii Farm Bureau. You have our written testimony in support. We want to protect this culturally important crop. This week we have hearings and bills on coffee labeling and MAC labeling. We're trying to fix those labeling laws. Why don't we start out right with Mamaki and get it right now instead of trying to fix it down the road? So again, we're in strong support protecting this important cultural crop that actually we see more and more being grown, and we want to grow this Mamaki industry while protecting the Hawaii brand. Thank you for the opportunity to testify.
All right, thank you. That's all I have registered to testify in person or on Zoom. Is there anyone else who wishes to testify on this measure? Seeing none. Members, any questions? Chair.
Department of Agriculture, are you here to, on Zoom? You requested in your testimony an additional inspector. How many vacancies do you have in the inspection division right now? Are you guys full up?
We don't have a labeling package inspection section anymore since the ref, and we have 2 vacancies for device inspection inspectors, but they're not specific to Mamaki tea labeling or macadamia nuts. They're inspectors that would help us to do that, but with all of these bills coming up, we've asked on the Mamaki tea as well as the coffee and macadamia nuts to be able to reopen our label inspection branch, our package inspection branch that was eliminated in the RIF back in 2009, 2010 area.
Okay, so if we gave you an additional inspector for this, we would have to stand up that entire branch again?
We would be reopening that entire section in Oahu, which we've been trying to rebuild. We have one package and labeling inspector who also is a device inspector in Hilo.
Are you using this bill as a vehicle for this to do that, though? That seems beyond the scope of this bill. I'm just a little hesitant to give this additional inspector if it's going to be too far out of the scope of Mamakiti labeling.
Well, this can be combined with the other bills that we've asked for personnel for full-time inspectors with, the coffee and also the macadamia nut, if it goes through. But right now, we have no inspectors in Oahu to be able to perform that function.
Okay, so if we put in the requested position, is there a place for that person, or are you saying you're going to necessarily need to stand up that division again for them?
No, we have a place for them here.
Okay, okay, thank you.
Thank you. Any other questions? Seeing none, moving on to the next bill. House Bill 978, House Draft 1, relating to electric utilities. First up, we have DCCA, Division of Consumer Advocacy.
Chair, Vice Chair, members, we'll just stand on our written testimony and support.
Thank you. Next, we have the Public Utilities Commission. With comments?
Chair, Vice Chair, members of the committee, the PUC stands with its written testimony, available for any questions.
Next, we have Hawaii Gas with comments. Not present. Is there anyone else here wishing to testify in this measure? Seeing none, members, any questions? Seeing none, let's move on to the next measure. Next up, we have House Bill 1316, House Draft 1, relating to the Department of Land and Natural Resources. And we have DLNR State Parks in support. Standing in support. And that's all I have registered to testify in person or on Zoom on this measure. Anybody else here wishing to testify? Seeing none, members, any questions? Chair Mariyoshi.
For DLNR. It's not too clear where the registration fees go. I think, did you mean for them to go into the special fund?
The registration fees would go into the special fund.
Okay, do other park registration fees go into the special fund as well from other sources?
Those parks that we do charge fees, yes.
Okay, okay, thank you. We'll make that change. Thank you.
Thank you.
Thank you. Representative Iwamoto.
Thank you. It's for DLNR. Hi, welcome back. Thank you. It seems like this is, will the registration fees cover all the costs of managing all of these registration? I mean, it feels like a lot of oversight, because this applies statewide, right? You have to do.
This, Pika Tomzik, DLNR State Parks, this is not totally my area of expertise. I have some information on it. We do have other reservation systems in place. This specifically would be at establishing a statewide system for 3 specific parks.
Okay, thank you.
Hopefully, thank you.
Any other questions, members? Seeing none, let's move on to our next measure. Next up, we have House Bill 914, House Draft 1, relating to water carriers. First up, we have DCCA, Division of Consumer Advocacy, with comments. Public Utilities Commission, with comments.
Aloha, good afternoon, Chair Marushi, Vice Chair Chun, and members of the House Committee on Consumer Protection and Commerce. My name is Andrew Okabe. I'm from the Public Utilities Commission as a utility analyst. I'm here on behalf of the Public Utilities Commission. I stand on the Public Utilities Commission written testimony providing comments on HB 914 HD1. Thank you. I'm available for any questions.
Thank you.
You guys have been doing a great job of it so far, but if you are going to send in your testimony, like he just did, please come to the mic so that everyone online can hear you too. Thank you.
Hawaii Department of Agriculture, in support.
Aloha, Chair, Vice Chair, members of the committee. Cedric Gates here on behalf of the Department of Agriculture. The department stands on its written testimony in support. Here for any questions. Mahalo.
Thank you. You have Department of Transportation in support.
Aloha, Chair, Vice Chair, members. Ed Sniffen with Hawaii DOT. Stand in support. Thanks.
Thank you. That's all I have who registered to testify in person or on Zoom. Is there anyone else who wishes to testify on this measure? Yeah.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Chris Nakagawa on behalf of Young Brothers. We stand on our written testimony in strong support. Thank you.
Thank you. Oh, go ahead.
Aloha, my name is Melissa Pavlicek. I'm here today on behalf of the Hawaii Harbors Users Group. We submitted our testimony as written only, but I just wanted to underscore that our industry supports this measure. Thank you.
Thank you. Anybody else wishing to testify on this measure? Seeing none. Members, any questions? Chair Mariyoshi.
Is the consumer advocate here? I don't think I heard them, yeah. Okay, I'll just kind of throw this question out generally to all of the testifiers who are here for this measure. There was testimony that stated that the automatic increase should not be pegged to the GDP price index. I'm wondering if anyone has a proposal of what alternative index, if any, this should be pegged to. Or I will make one up.
Hi, Andrew with PUC again. There are various GDPPIs you could use. We do note that we do use BCEI for decoupling purposes, but
What does that acronym stand for?
blue chips economic indices, I believe. But that is a forward-looking indice. If you were looking to complement the current language as proposed in the measure, you would look at an indice that would look at like a past year, and that's what BEA is portioned for. You could look at the Congressional Budget Office report as well, I believe. But there are a few other out there rather than just BEA.
So what would you have used for this one?
I don't have a comment as to which one is the most appropriate. If the committee wants us to use BEA, then we will more than gladly use that. It is an indice that does look in the past to determine what the inflation metric was for that time period.
Okay, I'm kind of inclined to blank that right now, and then just for all the testifiers to submit testimony for the next committee what index they'd like to use or what index they would suggest to use.
Okay, thank you, Chair.
Young Brothers. Does anyone else have a question on this one?
After.
Did you want to go? You can go.
Okay, well,
Sorry,
I
I
do
don't
have
know.
a question for Young Brothers as well. Thank you. Do you need to comply with the Jones Act and purchase new ships from American shipbuilders or something like that?
Yes, the answer is yes.
And does that affect your costs?
Yes.
And so we can compare your rates and what affects your rates and your expenses to other jurisdictions that, are they going to have to comply with the same Jones Act? Is it going to affect their costs in the same way it affects your costs?
If I can understand your question, other competitors you're
Not
talking?
competitors, but other jurisdictions where other shippers, because you're shipping in between US
Islands.
ports, or just
Right,
islands.
that's correct.
So they're both considered U.S. ports. So are there other carriers who are shipping between U.S. ports that must also comply with the Jones Act, who must also pay more for American ships?
Generally speaking, the answer is yes. I can't speak for the other carriers, but yes, that's correct. Your understanding is correct. Chair, if I may, on the question you had before on the GDPPI, just a bit of history. In 2021, there was a working group that was formed, and this is under Senator Lorraine Inouye that actually initiated this. And so there's a number of stakeholders that actually participated in this in 2021. It included the counties, DCA, the PUC, as well as the legislature. I think the chair of the transportation committees were there, the speaker, and also the president's office was also involved in this. And the consensus on the recommendations, which is set forth in the report, came up with the GDPPI as the index. So there's just a little bit of history on that as to why in this bill we're just following the recommendations as set forth in the working group's report.
If the working group was in 2021, why is the bill only coming up now, or has it come up in prior sessions?
It hasn't been come up in prior sessions, but yeah, it's. I mean, in terms of our understanding is that the commission, and maybe Andrew can answer that more, but I think we just wanted to clarify the language to make sure that the commission has the authority to establish this water inflationary carrier index adjustment factor using GDPPI. So that's the reason why we actually introduced this bill for the purposes of just making sure that the language is clear, that they have the jurisdiction to an authority to establish this adjustment mechanism following GDPPI.
Okay, I still might blank it out, or I might leave it in, but I'm definitely putting
Understood.
in a committee report
Yep.
note to the next chair to consider alternatives. In your testimony for the next committee, should they hear it, I suggest telling them exactly what you just told me
Great.
about the working group.
Thanks. Thank
Stay
you.
up there for a second, though. Rep. Yomoto, do you have any further questions? No. Okay. I am a little disturbed by the testimony from other testifiers that Young Brothers has come in for quite large increases recently, and as soon as the increase was granted, have been coming in for larger and larger increases. I am sympathetic that prices are going up,
Right.
inflation is going up. At some point, I think that regular price increase is probably warranted up to a certain degree, but why, can you kind of give the committee an explanation as to why your requests have suddenly been spiking?
Yeah, it's a good question, and I think this is one of the proposed solutions. This bill itself in actually establishing these rate mechanisms in place. We totally understand your issue or concern. We have the same issues and concerns in terms of, but this is one of the solutions is so that to give more transparency and predictability to not just only us, but also to our customers. So by establishing mechanisms, it breaks it up more, so it's basically much more phased in. It's not a silver bullet, though. It's not going to cure our rate increases, because as you know, or as mentioned in the bill, it's really to address inflationary costs, which we haven't been able to recover for. And the one is, it's the system itself in terms of the regulations in place where we're not able to adjust rates, and it's been since 2020 since our last rate increase, and so it takes a lot of time and money, and just in terms of filing an application to actually file a rate case, it takes a whole lot of time and money, and so that's the reason why a lot of times it comes in like these once every 3 or 4 years, and we're trying to break that cycle. So by establishing these mechanisms, it actually breaks it up better. And
Is the length of time a symptom of PUC, or is it that you folks don't request one every year, or
like other utilities, like for us and for water carriers, it's different from the electric utilities. But I think right now there's a 6-month process that we have to go through by statute. So it's in the laws under HRS 271G. So that's really the process that we have to undertake, that it takes at least a 6-month process to actually change rates. That's
Okay.
by establishing, go ahead, sorry.
Oh, no, so, I'm sorry.
No, so that's why, we felt that this would be one step to help to address your concern, is to actually establish these mechanisms. And that was exactly what the working group came up with, is the same concerns they're raising is what they were looking at. And so one of the solutions was this recommendation is, in order for us to be sustainable and to actually to basically be able to continue to transport goods between the islands, we have to have the ability to actually, at least the very minimum, recover inflationary costs, which is really, in our opinion, I think the working group's opinion was that it's a standardized index. It's something that's beyond our control. That's something that it's very objective. It's based upon an index that's well known throughout the nation. And so we felt that and I can't speak for, at least from the working group's perspective, I think that was the consensus that this mechanism would be at least a potential solution to address some of the concerns that you're raising. Hope I answered that correctly.
Yeah, this bill, though, requires the PUC to, so have you proposed this mechanism to the PUC in the past?
Yes, we did. And
what
it
happened with
was
that?
dismissed. We filed an application last year, but it was dismissed for the same reasons where there was a lot of questions as to whether or not we could establish a mechanism outside of a rate case, as well as, how we could do it. So that's the reason why we actually filed this measure, so that we can actually provide more clarity and authorization to the commission. So it gives them the flexibility to actually establish these kinds of mechanisms.
So within a rate case, could you establish an automatic mechanism, or are you saying that in a rate case, you could only establish the
We could.
smaller
We
jump each time?
currently, as you may be aware, we're currently we've filed a rate case for 2025. And so we have a request in there right now. So we're hoping that the commission and the consumer advocate, we're all aligned that this is the mechanism that potentially could alleviate some of the rate shocks that you're talking about.
So you don't need this bill then if it's already in for 2025?
I think, based upon what we read in the orders, there's a lot of vagueness, and there's a lot of confusion whether or not the commission has authority to actually establish a mechanism as part of either in or outside of rate case. And so that's why we felt that this bill was necessary. Also, too, that just to, like you said, it's there's a working group report, and we wanted to follow the recommendations.
So, okay, you're in the PUC on a rate case to request this.
Yes.
This bill, though, requires them to establish automatic adjustment mechanisms. Would you be okay with then leaving it to the PUC and having this change from a shall to may establish?
That's something we're willing to talk to them about in terms of whether it's, we understand their workload is high. And so, and this is not just for us, right? I think there's another carrier that's also applicable to this law, which is the Lanai ferry system. So we understand that there's another carrier involved. So yeah, and we just feel like it's very urgent for us, because in order for us to be sustainable, we need to have a mechanism in place to be able to recover at least inflationary costs.
Okay. What was your net profitability last year?
I don't know the exact numbers, but from the regulated side, we've been losing money every year. Yeah.
Okay, so you've been losing money for the past how many years, you'd say?
I'd say at least 3 to 5 years, at least on the regulated side.
Okay. Should sell your stock now.
At least there's 1 year I think we made money, but I think there was most of the time we're not even actually having to earn a rate of return. We haven't been. It's all been negative on the regulated side.
Okay. Okay. Thank you.
Yeah. Any other questions?
Any other questions?
Thank you.
Thank you. Okay, members, we're going to move on to the next measure, House Bill 1161, House Draft 1, relating to transportation. First up, we have DCCA Insurance Division with comments.
Good afternoon, Chair, Vice Chair, members of the committee. Jerry Bump, testifying on behalf of the Insurance Division, will stand on a written testimony providing comments.
Thank you. Department of Transportation, in support.
Lord Chair, Vice Chair, members, Ed Sniffen with Hawaii DOT, stand in support.
Thank you. Hawaii State Energy Office, in support.
Chair, Vice Chair, members of the committee, HSEO, we stand on our testimony and support and are here for questions. Thank you.
Thank you. Next, we have Tax Foundation of Hawaii with comments on Zoom.
Good afternoon, Chair and members of the committee. This is Jade McMillan on behalf of the Tax Foundation of Hawaii. We've submitted some comments on the measure and we'll stand on a written comment. Thank you.
Great. Thank you. Next, we have Hawaii Food Industry Association with comments on Zoom. Nope. Okay. That's all I have registered to testify online or in person. Is there anyone else wishing to testify on this measure? Seeing none. Members, any questions? Representative Iwamoto.
Thank you. I have a question for Transportation Director. Are the counties allowed to shift to a mileage-based road usage charge on their own? Do they require the state to authorize them?
I believe the state is required, they require the state to authorize them to have this base to charge, yes.
Okay, well, my second question is why do we need to allocate them any money to do that? I couldn't understand the cost part of just saying, go ahead, charge them that way.
Yeah, I think the cost is for us, for the DOT. We're assisting the counties in adjusting the collection processes for all of this. Right now, the gas tax is very elegant for all of us. I kick back and wait till DOTAX cuts me a check. But when we move to this road user charge platform for the state in July of this year, we got to start taking care of the data collection, the enforcement, and the funding collection for all those pieces. The DIT from the City and County of Honolulu are picking up a lot of the bulk of the work in order to do that. So we have our consultant working with the counties to ensure that everybody's tied back into the same system, so all of our residents pay the same way seamlessly.
Okay, so I'm imagining, well, I am a car owner, so we would pay our vehicle registration to the state, and then we indicate what our odometer reading is for that year.
Yeah, so the way it would work right now is based on the safety inspections. That's where we would collect the data on what you owe, based on the delta of what you ran from last year. Then everything would be collected at your registration. So when you pay your registration, you pay it to the City and County of Honolulu, and they disperse the payments to the state.
So, but if it's, okay, so, but if it's going to, if the county is setting their own amount and the money's going to the county, then where do you come in?
Yeah, so the way it all works is to ensure that we minimize the potential for overlaps of the different types of operations that are necessary. City and County of Honolulu takes the bulk of the collections for all of us, for all of the counties and the state at the registration fee. So there's a state registration fee and weight tax. There's a city registration fee and weight tax. They'll collect both of them. Then they'll disperse the payments to the state based on the requirements. It would be the same thing with road user charge. So after we take the data at safety inspections, that data will be transmitted to the city, who will bill out at registration of how much you owe. They'll collect for both the state's road user charge and the county's road user charge and disperse to the state.
Okay, thank you.
Thank you.
Chair.
So, Ed, I understand the concept of the road usage charge, I think. I'm thinking about plug-in hybrids. Do plug-in hybrids fall under this too or not?
Anything that's under the definition of electric vehicle in the federal government is under this. So plug-in hybrids are under that definition, I believe. And I can check for you.
Okay, so they'll get hit with this road usage charge, which I think that's fair, honestly. But they'll also be paying the gas tax occasionally.
Yes.
Is that right? Okay.
Yes, exactly.
Okay, thank you.
Thank you.
Right. Any other questions, members? Seeing none, let's move on to the next measure. Next up, we have House Bill 1301, House Draft 1, relating to transportation. And first up, we have Public Utilities Commission with comments.
Good afternoon. PUC stands on its written testimony with comments.
All right, next, we have Hawaii Association for Justice in opposition.
Aloha, Chair, Vice Chair, members of the committee. Evan Oye on behalf of the Hawaii Association for Justice. You have a written testimony, so we will stand on that, but just wanted to highlight a few of our main points. Our primary concern is the repeal of 279J, which includes the insurance statute, which regulates transportation network companies. And our other concern is primarily the removal of joint and several liability for transportation network companies which operate in the state. So those are our two primary concerns, and we'll be here for any questions. Thank you, Chair and Vice Chair.
Great. Thank you. Next, we have Lyft in opposition on Zoom.
Yeah, good afternoon, Chairman Matayoshi and Vice Chair Chan and committee members. Mahalo for the opportunity to provide testimony. Lyft submits this letter in opposition to HB 1301, a bill that would unnecessarily impose duties and liabilities on TNCs that will threaten the industry as a whole in the state. TNCs are technology companies, and designated TNCs as common carriers would completely eliminate the uniform statewide framework that governs the ride-shared industry in Hawaii's and has been working well for communities across the states. Courts have acknowledged that TNCs should not be treated like taxis or other common carriers. Since day one, we've built safety into every part of the Lyft experience before, during, and after the ride, which is unparalleled in the transportation industry. We've implemented strict policies in compliance with the TNC regulations to screen everybody who drives on the platform by requiring initial and annual background checks, conducting continuous criminal monitoring, and driving record checks, and providing community safety education created in partnership with the nation's largest anti-sexual violence organization. We've developed in-ride features that allow riders to share their location with family and friends, connect directly with Lyft support, and quickly and easily access emergency assistance from the Lyft app. After the ride, our safety team is available 24/7, so riders can always reach a live person if they have concerns, and so we can take action to help them help keep our community safe. These enhanced safety measures did not exist before the for-hire transportation industry, and even today remain unique to the ride-sharing industry. An increase in operational costs may be felt the hardest by people in Hawaii who rely on access to rideshare to get to work, access medical care, and obtain healthy food, and much more. At a time when people are already facing inflation and rising economic pressure, this bill, if passed, would only add to that uncertainty. So rideshare provides thousands of people in Hawaii with important earning opportunities and transportation options. People across Hawaii are driving with rideshare for supplemental income and helping vulnerable communities access essential services. Imposing the additional requirements for TNCs as proposed in this bill will result in increased costs to the consumer and unnecessary, as the current TNC rules and liability standards provide ample protection. For these reasons, we oppose the bill and welcome the opportunity to discuss the issue further with the sponsor and other representatives of this committee. Thank you for the opportunity, and I stand by for questions.
Thank you. Next, we have Uber in opposition on Zoom.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Zahid Arab, and on behalf of Uber Technologies, I'm here today to respectfully oppose 1301. The push to classify TNCs like Uber as common carriers doesn't make sense and could create more harm than good. Uber has been serving Hawaii for more than a decade, providing affordable and reliable transportation, and the regulatory framework we already have, like HB 1681, signed into law a few years ago, has been working well for everyone. There's really no reason to disrupt a system that's functioning effectively. Classifying TNCs as common carriers would impose unnecessary legal burdens and financial strain on both drivers and passengers. TNCs aren't like taxis or buses. We're technology platforms that connect drivers with riders, and we don't own or operate vehicles. Holding TNCs to the same liability standards as traditional carriers is not just unfair, it's unwarranted. If passed, this bill could hurt Hawaii's most vulnerable communities. Higher insurance costs and additional liabilities resulting from it will likely drive up fares, making it harder for riders, especially those on fixed incomes or in underserved areas, to afford the service they depend on. This could also lead to fewer earning opportunities for drivers that rely on the platform to support their families. In addition, we already meet high insurance requirements in uninsured and underinsured motorist coverage while passengers are in the car, which is far more than that of taxis or personal vehicles. The existing framework is sufficient and protects both riders and drivers. In closing, instead of complicating things with unnecessary changes, we should stick to what's working. The law implemented in Honolulu in 2016 is a proven model, and it's one that balances the needs of drivers, passengers, and the community. Thank you.
Thank you. That's all I have registered to testify online or in person. Is there anyone else wishing to testify on this measure? Seeing none, members, any questions? Seeing none, let's move on to the next measure. Next up, we have House Bill 624, House Draft 1, relating to school psychologists. First up, we have Department of Education in support. Next, we have the Hawaii Association of School Psychologists in support.
Aloha. My name is Leslie Bonnick. I'm the current legislative chair for the Hawaii Association of School Psychologists. In addition to standing on our testimony, I would like to respectfully respond to HPA's request to be part of our group. Unfortunately, they've been very adversarial towards us, and we feel that their involvement would be counterproductive for what Rep. Woodson's intent of this of committee actually is to sit down. In addition, we were not involved in the clinical psychologist licensure. There also seems to be confusion around us being under the Board of Psychology. I would like to remind everyone that we were added in title at the doctoral level about 5-6 years ago. So school psychologists in title are already under the Board of Psychology, but only at the doctoral level, whereas most school psychologists are actually a specialist level. We are not master's or doctorate. We're kind of in between. So I just wanted to add those clarifying points and note that I am here if there are any questions or concerns. Thank you so much.
All right, thank you. Next, we have the Board of Psychology in support.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Christopher Fernandez, Executive Officer for the Board of Psychology. I'm here to stand on the board's testimony, supporting and offering comments. Thank you.
Great. Thank you. That's all I have registered to testify in person or on Zoom. Is there anyone else wishing to testify on this measure?
Hello, Chair, Vice Chair, members of the committee. Nui Sebastian with HGA. We'll stand on written testimony in support of this measure. Mahalo.
All right. Thank you. Anybody else wishing to testify on this measure? Seeing none, members, any questions? Seeing none, let's move on to the next measure. Next up, we have House Bill 815, House Draft 1, relating to health insurance. And first up, we have Department of Budget and Finance in opposition.
Good afternoon, Chair Matayoshi, Vice Chair Chan, and members of the committee. BNF stands on its testimony in opposition. Thank you.
Thank you. Next, we have United Public Workers in support.
Hello, Chair, Vice Chair, members of the committee. Kamakana Kaimaloa, Government Affairs Manager for United Public Workers. You have our written testimony in strong support. Appreciate the Chair's introduction of this bill once again, and this bill actually highlights one of the biggest challenges that public workers are actually facing right now, and that's the cost of healthcare benefits. Happy to answer any questions you may have.
Thank you. Next, we have HGEA in support.
Hello, Chair, Vice Chair, members. Nui Sebastian with HGA. We'll stand on our written testimony in strong support of this measure. Mahalo.
Great. Thank you. That's all I have registered to testify in person or on Zoom. Is there anybody else wishing to testify on this measure? Seeing none, members, any questions? Seeing none, let's move on to the next measure. Next up, we have House Bill 463, House Draft 1, relating to eviction records. First up, we have Public First Law Center in opposition. On Zoom.
Aloha, Chair, Vice Chair, members of the committee. This is Ben Krebs for the Public First Law Center. You've got our written testimony in opposition, but basically we support the intent of this bill, and I apologize that I don't have video capability today. But we support the intent, but we oppose the provisions that require automatic sealing of court records without a case-by-case determination by a judge. So those provisions run head-on into the public's First Amendment right of access to the courts. The Constitution's promise of openness is critical to the integrity of our judicial system. While the judiciary in their written testimony does not comment on the merits or legality of this bill, please take a look at the last paragraph of its written testimony, which I think is consistent with our constitutional concerns. In our written testimony, however, we offer a technological solution. So instead of sealing cases, we suggest disassociating them from the tenant's name. So in our written testimony, you can see a screenshot, and it's an example of what happens when you put in a person's name who's got a sealed record. So the sealed case still comes up. It says case title redacted, but you can still, from the circumstances, you can glean what it is. So with our suggestion of disassociating, that's a technological solution instead of sealing. That way, a search of a tenant's name would not bring up the eviction case. So you still get to the same end result, but you don't have the constitutional concerns that we've noted in our written testimony. And also in our written testimony, we recommend that this committee focus the bill on discriminatory practices that are based on the status of an individual, not on sealed eviction records. And we explain that a little further in our written testimony as well. I appreciate you listening to my testimony, and I'll stand by for any questions.
Right, thank you. Next, we have Hawaii Appleseed Center for Law and Economic Justice in support.
Hello, Chair Matayoshi and Vice Chair Chun and members of the committee. My name is Susan Leh, and I'm representing Hawaii Appleseed Center for Law and Economic Justice in strong support of this measure. We stand on our written testimony in strong support, but just wanted to highlight our concerns about the fact that there's no provision in this bill about if tenants are looking to do a motion to reconsider or appeal. And our concern is that currently how tenant screening third-party sites work is that you can type in your name, and even if it was sealed later on, their records are still archived, sold in bulk. It exists in the Ethernet, and it's hard to remove. And without state-specific state-specific regulations in removing those, and like requiring, let's say, like every 30 days, those sites have to like make sure they're up to date and in compliance. These records will follow the tenant regardless of if the ruling was overturned. So we're just asking that the committee consider keeping the records sealed, or how the last testimony was, disassociated from the name within the 10 days of within the 10-day window of asking for a motion to reconsider, and if it is approved to be reconsidered, waiting until the case is no longer pending and fully ruled to release those records. Thank you.
Thank you. Next, we have Hawaii Realtors with comments. Let's see here. Next, Hawaii Workers Center in support. No. Then Dina Sheck in support. Nope, that's all I have registered to testify in person or on Zoom.
Oh, sorry. I must not have got it. It's Deja Ostrowski. I think you might have had my boss's name, Dina Sheck. I'm so sorry. Yeah. So I'm an attorney with the Medical Legal Partnership. Dina Sheck is our legal director. So I think if it's our testimony, I'm so sorry, Vice Chair.
Oh, go ahead.
Thank you, Chair and members of the committee. We're here to provide strong support, and I was going to stand on our testimony, but I think I want to respond to some of the things I've seen. We are direct legal service providers, so I'm an attorney that works specifically with tenants who are in eviction proceedings and doing these kind of things or have problems with their landlords. In particular, we work with a lot of the folks that you never see data on. So these are the folks who are having an active issue with their landlord, and they're coming to us early because we're trying to prevent that court action. No one really wants to see an eviction happen. And I think one of the things we have a constant concern about, which we highlighted in our testimony, is that folks a lot of times will not take a case that has merit with their landlord because they're so concerned about having a record, what that will look like for their future housing search. So we even have folks who may have really meritorious claims that they want to talk about. You'd be surprised how many times there's like arguments about the ledger, particularly if people are getting, any kind of tenant-based assistance or something like that. Or even we've had a rash of things where folks want to be evicted for things like leaving their slippers outside, the colors of curtains, feral chickens. You don't hear any of these stories because there's not an opportunity to tell them. And that's why we want to have an opportunity to tell folks, if you prevail against your landlord, it's not something that your future landlord is going to see immediately just by looking at eCourt COCOA. I'm completely cognizant of some of the issues of what it looks like now when someone can just use a third-party search engine that looks through things. But I'd ask that you don't stop this bill now just because it seems complicated and complex, because these are also things we're working through even in a criminal justice context. I know I'm aware of folks get their records expunged. The records are not automatically sealed, and that information is still available and out there in the online system even after they've done an expungement. So this is just for us to try one simple mechanism, and we're specifically talking about folks who prevail against their landlords. So this doesn't do anything about folks who still want to decide if someone's a good tenant. They're still absolutely able to do that. And I think we need to think as a system and ask you folks, where do these tenants who have records and don't have a single landlord in our state rent to them go? They sit in our shelter system and they have nowhere else to go. I think there's other ways that landlords who are operating a business can protect themselves by having security deposits and things like that. Our law allows you to evict someone within 5 days if they do not pay. They can take that immediately to court. The court costs $214 to file a fee. That's even still keeping someone's security deposit for non-payment of rent. So I think that those ideas of having a tenant that you have to evict and it being a problem are overblown based on the experience that I see. In fact, we see the opposite, where tenants have no ability to challenge the ledger with their landlord because they are given a 5-day notice to vacate. You're behind on rent based on my ledger. So thank you so much for the opportunity.
Thank you. Is there anyone else wishing to testify in this measure?
Good afternoon, Chair, Vice Chair, committee members. Mihoko Ito. I just wanted to note that I'm here on behalf of the Hawaii Association of Realtors, and we stand on our comments. Thank you.
Thank you. Anybody else? Seeing none. Members, any questions?
Going for the judiciary, but I don't think they're here, are they?
No, I didn't see them.
Okay. Well, I guess who's the first testifier? What was that organization again? Public First. Public First, you still there?
I am.
I notice you are stationed here in Hawaii, so I'm assuming you're familiar with our system. I had never heard of disassociation before, and some of the other attorneys I spoke to had also never heard of it. Is this not even a common practice? Is this a practice in the state of Hawaii?
Well, so it is somewhat of a new concept. It's definitely not something that is currently being implemented by the judiciary. And frankly, I'm not sure if the judiciary is fully aware of it. You know, one thing is when they're operating on like the back end, right? They're looking at their system from like, you know, whatever privileges the judiciary has, not necessarily from the public's perspective. But in my testimony, we've presented a screenshot, and that shows the association, right? So you put in the person's name, you do a search. Even if a record's been sealed, or if an entire case has been sealed, it still comes up. It's just the case name's redacted. So when we say disassociate, that is not like something that's going on right now. We're proposing like a technological kind of solution to it where
is this in any other state right now?
I honestly do not know, but you know, I don't know what the capabilities of Jeff's are.
So is your proposal to mostly just make sure the plaintiff doesn't show up if they are victorious in a summary possession matter?
Defendant. You know, because one of the things is, so first you're running up against the First Amendment. There's a right of access to the courts. So we're trying to propose something where this can move forward but not be delayed, you know, from uncertainty from litigation. But second, you know, if you seal the entire case, you're also going to be obscuring potentially, you know, abusive practices by landlords. So you do want these available to some extent, and that's, you know, we think we've offered an idea that's worth exploring. And frankly, that's something that, you know, the judiciary would need to weigh in on.
Yeah, no, I'm sorry. I thought this would apply to plaintiffs too if they were suing for lease violations. This is just summary possession though.
It would be how you folks, you know, set it up. But what we're trying to draw the distinction is there's a distinction between simply just disassociating something so it's effectively not available online.
It's an interesting idea. I just, without the judiciary here to weigh in on the technological feasibility of it, I'm not sure I feel comfortable.
For sure. It is something totally understood, and maybe it's something that could go in the committee report for the next committee.
Okay, but you haven't talked to the judiciary or anyone else about the feasibility of this thing you're proposing?
No, and to be clear, this isn't our bill, but no, we haven't had any conversations like that.
Okay, thank you.
Thank you. Members, any other questions? Seeing none, let's move on to the next measure. Next up, we have House Bill 467, House Draft 1, relating to foreclosures. First up, we have Elizabeth Ray on Zoom. Oh. She was the only person registered to testify on this measure. Is there anyone else wishing to testify on this measure, either in person or on Zoom? Seeing none, I guess there's no questions to ask of anybody, so let's move on to the next measure. Next up, we have House Bill 1325, House Draft 1, relating to housing. Let's see. First up, we have HHFDC in support. Democratic Party of Hawaii in support.
Chair, Vice Chair, members of the committee, my name is Jun Shin on behalf of the Democratic Party of Hawaii. You have our written testimony, so I'll just keep it short. The party supports policies that keep the people of Hawaii housed, and we support the expansion of protections that this bill lays out, because we think it's very important to provide adequate notice and resources to many of the tenants in affordable housing who English isn't their first language, they're kupuna, and they're people who are working very hard every day to just barely survive. And so we believe that the tenants shouldn't have to self-organize and self-advocate as it's been happening in a couple of these projects that have been either developed or in the process of developing. And so we're in support of this measure. Thank you for the opportunity to testify.
Thank you. Next, we have Hawaii Appleseed in support.
Hello, Chair Matayoshi, Vice Chair Chun, and committee members. Hawaii Appleseed stands in strong support on our written testimony that you guys have, and I just wanted to highlight again that this bill is for the stabilization of tenants, for the right to return, and studies have shown that sudden displacement and destabilization in general of housing results in really adverse impacts into health, education, financial stability, and future economic opportunities. So the impacts are severe, and want that to be recognized within our testimony. Thank you.
Thank you. Next, we have Medical Legal Partnership for Children in Hawaii in support.
Deja Ostrowski here for the Medical Legal Partnership. I just wanted to note in our testimony of support, we have some amendments that we kind of brought in last minute. And that's because after the first hearing, we actually had folks in the development industry approach us and say, this is something that we do all over. This is something that when we do projects in other states, they require. And they actually sent us some ideas of some language to have better enforcement to make sure that tenants are protected. So I don't want that to stop the bill, but I do think that there's some, just to point out that even as a Hawaii resident, I want to have what Georgia has and what they have always required for a long time. So thank you.
Great. Thank you. Next, we have Hawaii Workers Center in support. India Kote in support. Elizabeth Ray in support. Oh. Don Eileen Willits in support on Zoom.
Hi, yes, I support. Should I share a little detail of my testimony or?
Sure, if you would like.
Okay. So I am currently a part of the first phase of Kuhio Homes. And the reason my family and I are actually refusing to move is not only because of the lack of communication, but our priority wasn't put first. And the places that were offered were either run down, unavailable, or just too far from our schools and clinics. And I'm not technically full-time, I'm actually just a part-time worker, but it's really difficult for a single parent, to go through the motions of all of this. It is mentally draining as we fight against time in hopes to figure out a better solution to all the chaos.
Okay. That conclude your testimony?
Yes.
Okay, thank you. Next, we have Dina Sheck as an individual in person. Oh, okay, there you go.
Good morning, good afternoon, Representative Matayoshi and committee members. Thank you for holding this hearing. I'm scrapping my testimony to just say this. This bill is about accountability and enforcement. We're so pleased that HHFDC is supporting this because it is what normally happens and should happen. But as you can tell from what residents have been sharing, it's not happening. And so I have seen tenants show up at community meetings for years, often without required language access, share their concerns, questions, and needs to no avail. I have seen them follow up in writing with these concerns to no avail. They have attended HPHA board meetings, the Hawaii Public Housing Authority board meetings, to share their concerns and demands to no avail. Tenants recently asked for a meeting with the governor to address these concerns. He declined to meet with them, and he pointed them back to the developer's website, where the right to return consists of a Google form to stay in touch. And I have linked that to my written testimony if you would like to see the Google form. Tenants have been doing weekly sign wavings on School Street every Thursday, which at least has garnered some excellent media coverage, which I've also linked in my testimony. But the main contract holders, HHFDC, HPHA in particular, have not been holding the developers accountable. So although we appreciate their support today, and that is what this bill seeks to do. Add accountability and codify what the tenants have been asking for all along: a clear right to return, a clear process, clear communication, and accountability, so that they will be treated with respect throughout the relocation and return process. So hopefully we can, as Deja Ostrowski had mentioned, strengthen some of the language to add tighter enforcement, including possibly quarterly updates that are linked to funding, other measures to ensure that there are consequences to ignoring the law. But please, thank you for listening to the tenants, and it's exciting to please ask for your support of House Bill 1325. Thank you very much.
Thank you. That's all I have registered to testify. Is there anyone else here wishing to testify on this measure in person or in Zoom? Please go ahead.
Sorry, excuse me. Hi, good afternoon. My name is Lenda. I'm part of the community in KPT. My home is not affected by what's about to happen, but I am part of the community and I stand with my community full force, because what we're seeing is I feel like we've been looking down upon because maybe they look at us, we're from the housing, or, or uneducated or whatever it may be, but we would like you guys to take into consideration to please to help our community, and to pass this law, that we hope that mainland redevelopment people won't be able to continue to come to our island and take redevelopment because it's a profit thing, what they're trying to make. So we just hope that you'll stand with us as we are standing with our community in KPT. And there's a lot of us here. Some of them don't want to come up to speak because they're shy, but we are standing as a community regardless of, what's about to happen. One of our goals is to speak with Michaels and HPA. We've been sending letters, calling, but nothing has been coming back for us to meet with them so that we can sit down and fix this measure to work together. We're not against Michaels. We don't hate Michaels, but we would like them to give us the respect and the promises that they spoke about, that when they made the redevelopment, that families will be able to return to their homes and that will be able to afford the rent to live on the property for the new redevelopment. Thank you so much for your time this afternoon.
All right, thank you. Yeah, go ahead.
Good afternoon. When I came last month, and I know time is of the essence, forgive me, but that's what tutus do, yeah. So last month when I came, I heard people saying they stand on their testimony. What that mean? What they say is good enough? Can they add to it? Or when pow, all is said, all is written? What that means, stand on your testimony? No need talk no more? Pow?
Usually when they say stand on their testimony, it's that they've submitted written testimony and they just, that's good enough.
That's good enough.
Yeah. But could you please also state your name before you?
Oh, I'm so sorry.
Thank you.
My name is June. I'm a longtime resident of KPT, which we know stands for Cohill Park Terrace. And like Linda said, I'm not against redevelopment. I'm against the way they're going about doing it. You know, I heard this Wahine say, yeah, and I think she's from the island of Maui. She said something that captivated my heart and to this very hour. She said, it's not so much what you do, but it's with the heart that you do it with. And I believe that if these people truly loved us, because like I said over and over, we only can go around the mulberry bush. We don't can drive upstate, downstate, but we gotta live one with another. And I gotta see my people every week at the same old shopping center with a broken heart. These people, when they pow, go back mainland, go wherever they like go. But for us, who the promises are made to be broken by those who are making it, where can we go? We cannot go no place but here to you guys, because in a sense, you're like our parents. You're the steward of the land. You take care of us. You listen to us. And that's why we're here today, asking you. We're so thankful that this is the second time we're coming. And if there's another third time, we pray that it won't be 3 strikes you out. We pray that it's 3 times and you're good to go around the bend again. So just coming to ask you guys, please, kuku with your heart. Like that Wahine said, it's with the heart that you do it. And that's why I'm standing with my people. So, mahalo. Paul.
Thank you very much for coming.
You know, when I first came here, I never know nothing, yeah. And Susanna said for the first time, okay, introduce yourself. I literally never know. I literally stood up, faced the people and said, I'm so-and-so, and thank you. And I bowed to the people, and I turned around, and they were all laughing because they knew it was an honest thing that I don't know. I'm learning. I even had to ask our sister over there, what does PCP stand for? I'm learning. Teach me. And at the same time, love us. We are your island people. Thank you.
Right. Thank you. Is there anybody else wishing to testify on this measure? Oh, please.
Good afternoon. My name is Rona Mangayayam. I'm the Youth Services Director of Kukua, Kalihi Valley. Way back in 2022, when the plan for the KPT redevelopment was presented, me and my team brought some of our youth in our program who lives at KPT to go and see what the plan is all about. While we are on our way to that venue, one of our youth asked me, Auntie Rona, if they will move us out from Kalihi, will you accept us back in your program? That's a question that keeps ringing to me until now. A few weeks ago, we met some of our parents because some of their children, we will have an opportunity to bring them for a peer-to-peer mental health workshop in Oregon. And one of the parents lives at KPT. They are on the phase 2. And she said, I really don't understand what is happening. I don't know where we are going. I really don't know. And in our youth program, the questions we ask is that, how would you continue to be healthy? Because we want them to grow as young healers and young leaders in our island. What keeps you awake at night? And one of the students in our program at Dole Middle School shared her thought, and I will read. One thing I know of the KPT redevelopment, it will affect our accessibility to school, work, and other resources. We mostly rely on the bus for transportation, and here we live in close range to bus stops. Our current location is in walking distance to my school, my dad's work, and the PAC Resources Center, which has been very helpful to my mom. My parents are worried about having to start over, not having transportation to my dad's job, and my mom not knowing where to go and get help and resources if we are moved to a new place. They also like that we have our own yard as well as our own washing machine, which we may not have at the next place we get moved to. We also don't like the idea of moving away from our neighbors. We have come to love them, and we're afraid we may not have the same bond with neighbors if or when we move. I don't really like how they're doing this, knowing some people have been here most of their lives, creating memories for generations. To us, this is home. The right to return to a place is not just going to a building. It's going back to the roots, to the stories that they built with their ancestors, to a home that they've come to love, and where they will continue to strive and thrive as people of this island. If there's a law to protect them, give them assurance that they have the right to return to that home and place and neighbors, then that would ease those pain and hardship of transition if they have to be relocated because of redevelopments. So I ask you to please think of these youth and children as you consider this law. Thank you.
Thank you. Anybody else wanting to test? Go ahead.
Aloha Committee, Jesse Lippman. Been working for the last 3 years with the residents, with the management, the Housing Authority, and the redevelopment. I'm going to speak just as an individual so I can come from my heart and just ask, what are we doing here? Why are we moving out the most stable, long-term residents of the community, the lowest income with the least capacity to navigate change, to build a high-rise tower that wasn't in the plans that were presented to the community for 40 to 80% AMI, which would average about $80,000 a year, far more than the current tenants get, with no priority for Kalihi residents, with no involvement of the Office of Workforce Development for jobs or job skills or training for the community, to spend $224 million of our tax monies for a New Jersey private company whose leadership is under federal indictment for fraud and racketeering. That's what we're doing here. And these are the people that are getting moved out to go where? The park? A burnt down unit in Waianae? That's where we're getting sent. So I'm just want to speak on behalf of the community. The community's come together. They want to be involved. They want accountability. They're asking for somebody to step up. I support this. This is a step, but whether it's the state, the city and county, the housing authority, the developer, somebody needs to have accountability and leadership so the community can build itself up. We want to do that. Thank you.
Thank you. Anybody else wishing to testify on this measure? Seeing none. Questions, members? Seeing none, let's move on to the next measure. Next up, we have House Bill 553, House Draft 1, relating to insurance. First, we have DCCA Insurance Division with comments.
Good afternoon, Chair, Vice Chair, members of the committee. I'm Justin Chu with the DCCA, and we stand on our written testimony offering comments.
Great, thank you. Next, we have DHS with comments.
Hello, Chair, Vice Chair, members of the committee, Judamar Peterson, MedQuest Administrator. On behalf of the Department of Human Services, we stand on our written testimony with comments. We appreciate the intent. We are also requesting an amendment. Thank you.
Great. Thank you. Next, we have the Attorney General's Office on Zoom.
I am here in person.
Okay.
Good afternoon, Chair and members of the committee. Deputy Attorney General Andrew Kim. We provided written comments regarding the requirements of 2351 and possible deferment. Thank you. I'll be here for questions.
Okay. Thank you. Next, we have University of Hawaii System in support. No. Kaiser Permanente with comments on Zoom.
Sorry, I apologize. Good afternoon, Chair, Vice Chair, John Kirmitz on behalf of Kaiser Permanente. Kaiser stands on his testimony offering comments and available for any questions.
Great.
Thank you.
Next, we have Alzheimer's Association of Hawaii on Zoom.
Chair Matayoshi, Vice Chair Chun. Kobe Chalk with the Alzheimer's Association. In strong support of this measure, we just wanted to highlight that there are new therapies available for treating Alzheimer's that will actually delay the progression of the disease, but it requires early detection and then it requires biomarker testing to verify the diagnosis. And there's a several biomarker tests used in this, including others to rule out other forms of dementia, such as Lewy body dementia or vascular dementia that could be caused by a stroke. And we stand in strong support of this and are here for questions. Thank you.
Great, thank you. Next, we have American Lung Association on Zoom.
Aloha, Chair, Vice Chair, members of the committee. I'm Pedro Haro, Executive Director of the American Lung Association. We stand in strong support. You have our written testimony. I did just want to point out that it's incredibly important to be able to pass this as is. The industry will ask for it to be a medical necessity or to limit it to instances of cancer. It's incredibly important to point out that this is a test, and sometimes tests don't need to be a medical necessity in order to be able to find things that are important. A lot of the cancers, a lot of the diseases that we find are because doctors have the ability to be able to order tests to determine what is wrong with their patients. And we need to allow doctors to be able to make that decision rather than allowing people in offices to make those decisions for them. So we really support this measure and ask you to pass it as is. We'll be here for questions. Thank you.
Great, thank you. Next, we have HMSA with comments.
Good afternoon, Chair Matayoshi, Vice Chair Chan, members of the committee, well and out HMSA. We just want to stand on our comments available for questions. Thank you.
All right, thank you. Next, we have Hawaii Association of Health Plans with comments.
Good afternoon, Chair Matayoshi, Vice Chair Chun, members of the committee. Rachel Wilkinson on behalf of the Hawaii Association of Health Plans, and we stand on our written testimony offering comments. Thank you.
Great, thank you. Next, we have American Cancer Society Cancer Action Network in support.
Thank you, Chair, Vice Chair, and committee members. Cynthia Au on behalf of the American Cancer Society Cancer Action Network, or ACS-CAN. Thank you for the opportunity to testify in strong support of the bill. We ask that the committee pass this critical legislation as is to improve patient access to care. Timely access to comprehensive biomarker testing will enable more patients to access the most effective treatments for their disease and can potentially help achieve the triple aim of healthcare: better health outcomes, improve quality life, and reduce costs. Progress is improving outcomes. Cancer outcomes increasingly involves the use of precision medicine, which involves information about a person's own genes or proteins to more accurately diagnose, treat diseases like cancer. Biomarker testing for screening purposes is not covered under this bill. I'd like to draw your attention to the written testimony submitted by Natalie Hyman and Susan and Peter Hirano. Both these stories highlight the inadequate coverage of biomarker testing by insurers in Hawaii. Natalie and Susan both received biomarker testing that was ordered by their oncologist to guide treatment of their cancers, but they received big bills because insurers did not want to cover the testing. A peer-reviewed study found that 64% of Hawaii's policies reviewed were more restrictive than the National Comprehensive Cancer Network guidelines for biomarker testing for advanced breast, non-small cell lung cancer, melanoma, and prostate cancer. Ensuring equitable access to biomarker testing by improving coverage for access to testing across insurance types is key to reducing health disparities. In order to make Hawaii patients have access, they need this game-changing testing. The legislature should ensure that necessity is determined by doctors and not the latest, by the doctors and the latest evidence, but not insurance companies. 20 other states have enacted this bill. Thank you. I'm available for questions.
Great, thank you. Next, we have Natalie Hyman on Zoom.
Hello, my name is Natalie Hyman. I'm a patient advocate living with stage 4 metastatic breast cancer, and I'm in strong support of this bill. I did submit my written testimony, so I've learned from my previous committee that I will not read it, but I hope you all will read my written testimony, which explains why I'm here. But just to highlight a couple of issues, the reason we need this bill as is and not amended is that our health insurance companies in Hawaii are currently currently denying medically necessary biomarker testing. I personally have had that experience twice where my oncologist ordered what would be considered standard of care, medically necessary biomarker testing to determine what cancer drug will work on my cancer, and my insurance plans denied it. The first test was $5,800, and the second test was $9,650, both of which I appealed and I'm still fighting over with my insurance plans. Now, the current definition in Hawaii statutory law of medical necessity says the insurance plan's medical director has to agree with the doctor that it's medically necessary. So we're putting our fate in the hands of the people who benefit, financially from denying care. So the bottom line is, if you allow this medical necessity nonsense to get in this bill, you are letting them get away with inconsistent decisions. They're not following the recommendations of the treating physicians. They're not following professional standards of care or current clinical practice guidelines for cancer and perhaps other diseases. So patients should be able to get biomarker testing when it's ordered by their doctor and there's sufficient evidence that it will help guide their treatment. But that's not what's happening today. And so we cannot allow the insurance companies to dictate and use the vague and ambiguous current definition of medical necessity to now muddy the waters for biomarker testing. There's a reason the bill was written this way. It's to force them to cover things that they don't want to cover. Thank you so much for your time.
Hey, thank you. That's all I have who registered to testify in person or on Zoom. Is there anyone wishing to testify in this measure?
Good afternoon, Chair, Vice Chair, members of the committee. I'm Shane Morita. I'm a surgical oncologist. I've been in Hawaii for 16.5 years. My father died of cancer 20 years ago. I can tell you that there's been a major paradigm shift in cancer care, and using precision medicine and to better tailor therapy with molecular biomarker testing is extremely important. So I strongly support this. Appreciate the opportunity. Thank you.
Great, thank you very much. Anybody else wishing to testify on this measure? Seeing none, members, any questions? No, I have a question for HMSA, really quick. So I just want to clarify one thing. So currently, without this bill, HMSA and mostly all insurers do cover some type of biomarker testing. Is that correct?
Under medical necessity.
Under medical necessity.
Yeah, and I apologize. I can't speak to Ms. Hines' case, but we'd be happy to look into it if she would be able to provide us with the information to kind of go back and kind of close the loop on that. But under medical necessity.
Oh, yeah, okay. Yeah, no, my question was just because, some of the issues have been brought up about the essential health benefits. And so, one of the essential health benefits is laboratory services where usually diagnostic testing is covered. So I just want to clarify that biomarker testing is already offered.
That's my understanding. That's how we replied as well to the auditor study.
Okay.
Thank you.
All right, thank you. Any other questions, members? Seeing none? Okay, the next measure on the agenda is House Bill 557, House Draft 1, relating to telehealth. And first up, we have DCCA Insurance Division with comments.
Good afternoon, Chair, Vice Chair, members of the committee. DCCA stands on its written testimony providing comments.
All right, thank you. Next, we have Department of Health with comments.
Aloha, Chair, Vice Chair, members of the committee, Lauren Kim, Department of Health Planning and Policy Officer. We're offering comments as well as simple but yet significant amendments intended to basically swap out the current House draft with our amendments. Due to uncertainties about where federal health policy is going, we think it is prudent to extend the sunset date for the audio-only reimbursement in Act 107 SLH 2023 to next year and see where we are then. One of the concerns is, are they going to put restrictions on telehealth or audio only for reproductive health, for example? So locking this in stone now in statute may be premature, and we really need to see how federal health policy is going to shake out. Thank you for the opportunity to testify.
Great, thank you. Next, we have Department of Human Services. with comments.
Hello, Chair, Vice Chair, members of the committee, Judimar Peterson, MedQuest Administrator. On behalf of the Department of Human Services, we stand on a written testimony offering comments. We understand this is a complex issue, and we are available to discuss and working through any of the issues. Thank you.
Right. Thank you. Next, we have Hawaii State Health Planning and Development Agency in support.
Good afternoon, Chair Matayoshi, and Vice Chair Chun, and committee. SHPTA is in support of this bill. We also think there's some nuanced issues there. I very much was impressed by the Department of Health's recent admonition about the fact that the new administration could be canceling some of these services. We think audio only has been very helpful, particularly in behavioral health circumstances, more than in other areas. And certainly in that area, it needs to be considered because there are so many circumstances in which it's really difficult to get the video communication which we'd like to have. So we stand with our testimony and think that that concern expressed by the Department of Health was very, very important. Thank you.
Right. Thank you very much. Next, we have AARP Hawaii in support.
Good afternoon. I'm Audrey Suga Nakagawa, the Advocacy Director for AARP, and we stand on our position in strong support. And I, too, would like to advocate for the kapuna about the value of audio-only technology, of being able to access healthcare in that regard. Not everyone is digital savvy, and there's sometimes difficulties with connectivity and the affordability of interactive type of devices. So again, having the audio-only as an option is very, very important to our kapuna. Thank you.
Thank you. Next, we have American Cancer Society Cancer Action Network in support.
Thank you, Chair, Vice Chairs, and committee members. The American Cynthia Al on behalf of the American Cancer Society Cancer Action Network. The American Cancer Society Cancer Action Network supports the intent of the bill for further discussion. Cancer patients are already facing tremendous challenges, and physician and specialist shortage in oncology has only added to their struggles. This is not just inconvenient, it can also be physically and emotionally exhausting for those already struggling with life-threatening illness. Access to healthcare providers is critical to ensure that patients receive the best possible care and support. With telephonic telehealth, patients in rural and underserved areas can easily connect with specialists and receive timely recommendations or answers to their questions. The legislature can help to ensure that all patients have access to the care they need, regardless of their location or ability to travel. So thank you again for the ability to support the intent of the bill.
Right. Thank you. Next, we have Healthcare Association of Hawaii with comments.
Good afternoon, Chair, Vice Chair, members of the committee. Hilton Raythor for the Healthcare Association of Hawaii. We stand on our written testimony asking for amendments. Thank you.
Great. Thank you. Next, we have HMSA in opposition.
Thank you, Chair, Vice Chair, members of the committee. While we did submit testimony in opposition, we do wholeheartedly support the intent of perpetuating Act 107 from 2023. Our main concern now is that, as currently written, some of the loosened guardrails for initiation and maintaining of the audio-only telehealth through audiovisual telehealth was removed. Also, we would like to point out that we do feel that the 80% reimbursement rate that was agreed upon in 2023 would be appropriate, given that the stakeholders came to the table 2 years ago. For those reasons, we request amendments, and we would like to see this access for behavioral health through audio-only telehealth continue. Thank you.
Right. Thank you. Next, we have Aloha Care in support on Zoom.
Good afternoon, Chair Matayoshi, Vice Chair Chun, and members of the committee. Thank you for the opportunity to testify on HB 557 HD1. My name is Sari Lynn Curtis, providing testimony on behalf of Aloha Care. We've testified in support and submitted written testimony. We would like to underscore our support on this measure on the principle of access to care, particularly for the Medicaid population. We serve over 70,000 Medicaid and Medicare duly eligible members across all islands. This includes Kapuna, residents in rural and remote areas, as well as those in underserved urban areas. We support this measure as one way to improve access to care, especially given our state's provider shortages. We'd also like to underscore our support of reimbursement parity for telehealth. We understand a telehealth visit is not the same as an in-person visit, but we're prioritizing access to care. We concur with CMS, the Centers for Medicare and Medicaid Services, in their final rule that practitioners should always use their clinical judgment in deciding to furnish services via telehealth, whether the use of interactive audio-only technology is sufficient to ensure that appropriate care is being delivered, including scheduling in-person care as needed. Mahalo for allowing me to testify in support of HB 557 HD1 on behalf of Aloha Care.
All right, thank you very much. Next, we have Hawaii Primary Care Association in support.
Hi, Eric Abe for the Hawaii Primary Care Association. You have our rather lengthy testimony on this. I just wanted to provide a little bit of background behind this bill. During the interim, in light of the sunset of Act 107 at the end of the calendar year this year, the Hawaii Primary Care Association did have discussions with Representative Chun, who had agreed to introduce the version that, the original version of this bill. The intention of that draft was to flesh out all of the main elements of Act 107 in light of the significant changes that were made to federal law as of December 9th of 2024. A lot of that is discussed in the testimony. It was subsequently amended by the Committee on Health. However, as noted in our testimony, the draft as it presently sits is problematic. It basically would deny certain benefits that arguably have accrued since January 1st of 2025. Based on my cursory review of the testimony that was submitted today, you know, it seems as though Department of Health, the University of Hawaii, the Healthcare Association of Hawaii, and Queens, they all realized that the safest thing that the legislature could do on this issue would be to extend Act 107, as they pointed in their testimony, for 1 year. The only trouble with that is arguably because the definition has been changed as of January 1st, the insurance commissioner has yet to make a determination on how the state is going to actually implement that change. If they should determine that they're going to need to come up with rules or whatnot, just the rulemaking alone is going to take months. And so perhaps if that is what this committee is inclined to do, you may want to consider extending it from 1 year to maybe 2 years. And that way, to a certain extent, Act 107 was for 2 years. And so it'll basically give these new changes a chance to actually see how it plays out. With that, I'll be happy to answer any questions.
All right, thank you. That's all I have registered to testify online or in person. Is there anyone wishing to testify on this measure? Go ahead.
Aloha, I'm Melissa Pavlicek. I'm here today on behalf of the Hawaii Mental Health Coalition. Apologies if our testimony didn't come in. I have with me today one of our representatives from the Hawaii Counselors Association.
Hi, good afternoon. My name is Gino Luciano. I'm the president of the Hawaii Counselors Association, making up a part of the coalition.
We also represent the Hawaii Psychological Association, the National Association of Social Workers, and the Hawaii Marriage and Family Therapists, and we strongly support this bill. Our highest priority is to ensure that behavioral health services can continue to be delivered by telehealth. And as you've heard from others, and Gina will share with you briefly today why this is so important, we would prefer to see no sunset on the reimbursement for those services. In addition, we do support audio only to establish the initial relationship and to maintain the relationship with the patient, as well as to support 100% reimbursement. But for purposes of our testimony today, I really want to underscore we support moving forward a bill that will allow us to continue to provide behavioral health services by telehealth.
Thank you. And briefly, as a former provider and worker of contracts that service people in rural communities throughout the state, not just Oahu, Maui, Big Island, the need for access for audio-only telehealth is paramount in making sure that these reach broader communities. Thank you.
Thank you. Is there anybody else wishing to testify on this measure?
Yes, I would like to.
Okay, sure, go ahead.
Hi, good afternoon, Chair, Vice Chair, and committee members. I'm Dr. Jonathan Opeyam on the Big Island, and I'll be brief. What I'd like to say is there's a need for this telecommunications aspect to continue. There are times when I have appointments to see my PCP, and for whatever reason, my medical trans either doesn't show up or doesn't come, and I have no way to keep the appointment in order to get my medication that I need every month. So I just wanted to interject that into the testimony. My doctor and I, my PCP, are standing on what we've submitted, but I wanted to bring this to the committee's attention. Thank you for your time.
Thank you very much. Is there anybody else wishing to testify? Seeing none. Members, any questions? Now, I have a quick question for Department of Health.
Yes, Vice Chair.
Good afternoon. So I just want to clarify your testimony. So with the reference to Act 107, so that's the original Act 107 and not the original version of this bill or the HD1. Is that correct?
Yes, so it's the session law as it is authorizing current audio-only services and reimbursements today.
And you don't think there's an issue with referencing the federal code 42, I think it's
I'm not familiar with
410.
the code that Mr. Abe referenced. I'd have to take a look at that and consult with my AG. But again, we're just recommending the safest move in a time where things are unpredictable would be the safest place just to extend the sunset date however many years you wish.
Okay, all right, thank you.
Thank you.
Members, any other questions? Seeing none, let's move on to the next measure. Next, we have House Bill 712, House Draft 1, relating to health. First up, we have Department of Health with comments.
Hello again, Lauren Kim, DOH. 340B is a very, very important program. My department relies on it to provide critical service to some of the most vulnerable populations, in particular in our harm reduction services branch. It is also an important program for our colleagues in the private sector who rely on this. This contributes to their ability to take all comers, regardless of insurance or ability to pay. We are in the process of clarifying the enforcement mechanism for this. We are in an active discussion both with private sector stakeholders, the Department of the Attorney General, and ask that this measure be passed out of committee so that those conversations can continue. I'm available for questions. Thank you.
Great. Thank you. Next, we have Shipta in support.
We stand on our testimony, Chair and Vice Chair.
Okay. Standing on testimony and support. Next, we have DCCA Office of Consumer Protection with comments.
Aloha awinala and good afternoon. We are the other agency involved in those conversations that Mr. Lauren Kim had just mentioned. Our concerns with the enforcement mechanism as drafted really, I think, prompted and pushed some of those to the forefront. And we will continue to work with them to try and figure out how a bill that seems to be aimed at protecting federally qualified health centers and service providers who are entities fits into a statute that protects consumers who are natural persons and not businesses. Available for questions if needed. Thank you.
Okay. Thank you. Next, we have Hawaii Primary Care Association in support.
Yes, Eric Abe for the Hawaii Primary Care Association. We're in strong support of this bill. We offer committee report language and draft language for your consideration. It's a friendly amendment.
Right. Thank you. Next, we have Healthcare Association of Hawaii in support.
Hilton Raithel for the Healthcare Association of Hawaii, testifying in strong support of this bill. Congress set up the 340B legislation to provide a funding mechanism to support hospitals and federally qualified health centers. It has been in place for many, many years. However, recent actions by drug manufacturers have inhibited the use of this program here in the state of Hawaii. There is, at least on the hospital side, a $30 million a year impact of lost revenue. As you've heard from other testifiers, we are working actively with the Department of the Attorney General, with the Department of Health and other agencies on the enforcement mechanism, and we are very working actively to resolve that during this particular session. So thank you very much for allowing us to testify, and we are available for questions. Thank you.
Right. Thank you. Next, we have Pharmaceutical Research and Manufacturers of America in opposition.
Good afternoon, Chair, Vice Chair, committee members. My name is William Gu, appearing on behalf of PhRMA, which is the trade association for many of the larger drug companies in the United States. PhRMA stands on its written testimony in opposition to the bill. I would like to add one comment. Contrary to what the bill may imply, the accessibility of 340B discounted drugs to covered entities is not really an issue. However, due to the recent proliferation of the number of contract pharmacies that are actually being utilized by these covered entities, some of which are not even located in Hawaii, and a lack of transparency as to who the recipients are of these discounted drugs through these contracted pharmacies. Some of PhRMA's members are questioning whether or not these patients are actually qualified to receive 340B discounted drugs, which is really the intent of the program. And this bill essentially affects their ability to do so. Thank you for the opportunity to testify. Here to answer any questions.
Great. Thank you. Next, we have the Queen's Health System in support.
Aloha, Vice Chair, Chair, members of the committee, J.C. Mikulak on behalf of the Queen's Health System. We'll largely stand on our written testimony. This bill helps really implement and preserve the intent of the 340B program, the federal program. I would just also note that as a colleague that was just up here talking stated, we have an annual requirement that we actually have to report to HRSA on the use of this particular program. That includes an incredible amount of data in terms of who's actually getting these benefits and so forth. So there is an oversight, and all of our hospitals have reporting and auditing requirements built into our policy so that we're following the law to the T. So thanks very much.
Thank you. Next, we have the Hawaii Health and Harm Reduction Center in support on Zoom.
Aloha, Chair, Vice Chair, and members. Nico Sleverins with Hawaii Health and Harm Reduction Center. Mr. Kim's point is well taken, and we're fully supportive of that. We do not serve people who have means or who are gaming the system. We are serving largely the unsheltered homeless in Honolulu. We also provide medical case management services to people living with HIV. We serve members of the transgender community. The 340B rebate program enables us to provide additional support to people with limited or no economic means. Mahalo for the opportunity to testify.
Thank you. Next, we have the Waianae Coast Comprehensive Health Center in support on Zoom.
Aloha, Chair, Vice Chair, members of the committee. We stand upon our written testimony in strong support of this measure. Thank you very much.
Thank you. Next, we have Biotechnology Innovation Organization in opposition on Zoom.
Good afternoon, Mr. Chair and members. Brian Warren with National Biotech Association. 340B entities have access to steeply discounted drugs, which they can dispense to patients and receive reimbursement by commercial payers at the full price, and they keep the difference as revenue. The 340B program has wonderful intent. However, it's experienced exponential growth in recent years. Yet this growth has been primarily in areas that deviate from the 340B program's original intent. Safety net clinics such as FQHCs are a very worthy source of these discounted medications, yet they only make up a very small minority of the 340B program. Instead, hospitals and for-profit pharmacies have found out how to game the system by expanding into wealthy neighborhoods. However, adding more contract pharmacies hasn't increased patient access. All this has done is allow hospitals and pharmacies gaming the system to expand more. In a 2022 analysis of 340B claims, that as few as 1.4% of patients overall at contract pharmacies even saw a portion of the discount. The proponents might say that 340B does not cost taxpayers money, but that's not true. When 340B medications are dispensed, the employer, health plans, or state Medicaid no longer gets that rebate because those medications have already been discounted. So under federal law, state Medicaid does not get that rebate. So this costs Hawaii, the state of Hawaii, money. Similarly, it's not true that manufacturers are cutting any 340B medicines. Some members of ours have been asking entities that use contract pharmacies to upload claims into clearinghouses so that those claims can be verified for accuracy and so that duplicate discounts and diversion of medicines, which are both prohibited under federal law, can be closely tracked. That's what this bill is seeking to prohibit, and that's why we oppose this bill today. Thank you. I'm happy to answer any questions.
Great, thank you. Next, we have Kelsey Kaku in support on Zoom.
Good afternoon, Chair, Vice Chair, and members of the committee. I stand on my written testimony in support. I was born and raised on the Big Island and am currently serving as an ambulatory care pharmacist for our community. And the intent of the 340B program is to ensure eligible patients have access to medications. The cost savings from this program are used to expand services in our community, and contract pharmacies serve on behalf of the covered entity to further extend that access and outreach. So this bill is essential for us to ensure this access is available for our patients and our community. Thank you so much for the opportunity to provide testimony today.
Great, thank you. That's all I have registered to testify on this measure. Is there anyone wishing to testify? Yeah, go ahead.
Good afternoon, Chair and Committee. Mike Robinson, Hawaii Pacific Health. I believe we submitted our testimony in writing, so we'll stand in our written, and we are in strong support of this bill. Hawaii is made up of a system of nonprofit healthcare delivery system, so I just want to say that a lot of the anecdote you're hearing is the mainland experience in terms of arbitrage and accusation of that. That does not occur here in the state of Hawaii. So I just want to make that point to counter on what we've heard today. Thank you.
Thank you. Anyone else here wishing to testify in person or on Zoom? Seeing none, members, any questions? Chair Mariyoshi.
For Hilton. Was the point of 340B to pass on some or all of the discount to the patients, or was it meant to be a program to allow and encourage hospitals or other pharmacies to expand into more rural areas?
It was intended to provide a funding stream for hospitals and FQHCs to better support the community for those who are underinsured or uninsured. So it was not intended specifically at a patient level, but more at a community benefit level. So that was the intent of the legislation.
Okay, so there's no requirement to pass on your savings to the patient from the discounted drug costs?
No, it was never intended to, sorry, my policy person is not here. No, it was, our understanding, it was not intended for, to have a benefit to the individual patient. It's about access to facilities that serve patients and provide, and as was mentioned by one of the other testifiers, all of our hospitals in the state are not-for-profit. They're here to serve the community, and this revenue stream is a funding stream that helps them cover services for and make up that difference. It may be, for services to uninsured and underinsured individuals in the community. So it allows them, it's a funding stream for setting up resources for providing staff or providing services that are not necessarily covered by either government or non-government insurance.
Thank you.
Thank you. Any other questions, members? Seeing none, let's move on to our last measure. House Bill 250, House Draft 1, relating to health. First up, we have Department of Health in support.
Lauren Kim, DOH, Department will stand on its testimony in support. Thank you.
Great, thank you. We have SHPTA in support.
Aloha again, Chair Matayoshi, Vice Chair Chun, and members. SHPTA is obviously in support of this bill. We worked on it. Prior authorization is a difficult problem for all of us in healthcare, as you all know. There are a number of bills out there, I think 7 of them this year, 4 that would speed up the process, provide the right specialty for the right problem that's being adjudicated, and all those things we support. This bill, however, it goes beyond. Well, there are also 2 bills that promote mandatory reporting to SHPTA. So we have all the data, we know what the facts are, and we understand how prior authorization is working in our state. Of course, we support that. This bill goes beyond that, looking for a solution to the problem that will take us a year or 2 to actually work on. But the issue here would be for to look at the science that's out there, and it's there. The science is there in terms of guidelines, appropriate use criteria, standards for all medical conditions that are being adjudicated under prior authorization. If we as a state could agree on the standards that we apply to all these factors among the insurers, the doctors, the hospitals, and the consumers, we could then automate this process, and it would be done. The decision would be made before you leave your doctor's office or as you're being admitted to the hospital, rather than later with all the problems attached to it. Is it too complicated? No, I don't really think it is. The science is there. When I was at the American College of Cardiology, for heart failure, we have 20 different or 30 different versions of how heart failure is adjudicated. We've done all this science. It's peer-reviewed by many, many different parties, including government entities, so that we understand how we can be very, very specific about looking into the complication of the science today to understand what is necessary care, what is appropriate care. So we create this Hawaii healthcare appropriateness and necessity body. It's a work group, and I don't think my correct testimony was uploaded today. It looks like to me, at least the package I brought from my office was my old testimony instead of HD1. But in the new testimony, we wanted to say that of the 15 people on this group, we think the most efficient way, after talking to members of the community, to appoint that is to have, out of the 15, 5 are insurers appointed by the Hawaii Association of Health Plans. 5 are providers. They're appointed by the Hawaii Healthcare Association of Hawaii from hospitals, the Hawaii Medical Association for doctors, the Primary Care Association for the FQHCs and primary care folks. And the 5 consumers would be EUTF, the State Health Coordinating Council. So in other words, it's an easier way to get there with the right kind of people to put this together. At the end of this, it's not mandatory, but we want to see if people will follow it and will make it happen, because it would benefit all of us. And we believe, once again, Hawaii can do this first, and the rest of the nation might just follow along, because it's a real solution to the problem. So we're here for questions if you need. Thank you very much. Mahalo.
Great. Thank you. Next, we have Hawaii Association of Professional Nurses on Zoom. Not present. Next, we have Hawaii Medical Association in support on Zoom.
Aloha, good afternoon, Chair Matayoshi and CPC Committee. Dr. Elizabeth Ignacio, Hawaii Medical Association. HMA stands on our written testimony, available for questions, Chair.
All right, thank you. Oh, I also have from Hawaii Medical Association, Dr. Gerald Garcia on Zoom.
Aloha, everyone. Thank you for the opportunity So from the Hawaii Medical Association, along with Dr. Ignacio and Dr. Jerry Garcia, we do support HB 250 HD1 with amendments, and I'm also available for questions. Thank you.
Right, thank you. Next, we have HMSA in opposition.
Aloha Chair, Vice Chair, members of the committee, Don Karisu on behalf of HMSA. First off, we just want to thank the committee for really taking the time to understand this very complex and nuanced issue, and want to just say that we respectfully oppose this version, HB 250, as we believe that some of the requirements that were inserted are quite unrealistic, and actually will end up stressing the system further and creating more administrative burden for the providers whom we are trying to help lessen the burden for. We also believe that any additional statutory requirements could also force health plans to go back to the insurance commissioner to negotiate premium rate increases. And so we just want to state that, again, we're opposed to this version of the bill, but we are not opposed to improving the prior authorization process and really working collaboratively with stakeholders. Just want to say that HMSA provided comments, and I just want to highlight some because it's quite, like I said, nuanced and complex. I just want to note for the committee that there are actually CMS requirements that are being required of health plans starting in 2026, meaning health plans are already working towards implementation. And these new requirements will continue to help to address the concerns raised about prior authorization frustrations. So under these new CMS requirements, PA timelines will be shortened further, helping to reduce the burden associated with PA processes. Transparency around medical necessity criteria and PA reporting will be strengthened, and the adoption of electronic PA processes will be required. And so we believe that it would be premature to add any new statutory requirements given that these new CMS requirements are pending and health plans are actively working towards implementation. Also to note, just internally, we want to thank HMA, their doctors and their leadership, and also, of course, Dr. Lewin for his leadership in continuing to think about this because we understand that there are challenges, and we have been really committed to making forward progress internally as a health plan. It's noted in our testimony, so I'm not going to read it to you. I would just ask that note for the committee that there is an administrative version of this bill in the Senate that is quite clean. It does speak to reporting, and just wanted to say that if the committee chooses to move this version of the bill forward, we have noted some amendments, including moving this the reporting requirements instead of under SHPTA to the insurance commissioner, who's the appropriate authority overseeing insurance and consumer protection in Hawaii, and also just asking for some language changes. I'll be around for any questions. Thank you so much.
Great, thank you. Next, we have Hawaii Association of Health Plans with comments.
Thank you, Chair, Vice Chair, members of the committee. Rachel Wilkinson on behalf of the Hawaii Association of Health Plans. And we stand on our written testimony providing comments. Thank you.
Great. Thank you. Next, we have Mohala Health LLC in support on Zoom.
Hello, I'm Esther Smith, and I am here to speak about the not so nuanced impacts that are going on with patients across our state due to the inappropriate burden of prior authorizations. 90% of prior authorizations are ultimately approved according to our insurance company executive friends. And if that is true, then 90% of prior authorizations only cost us money, cost the system money, and cost the patient delay in care. So in this day and age, 90% of a process being entirely useless and costly is not appropriate and is something that could be addressed in a less nuanced way. Further, prior authorizations are preventing hundreds of people from being seen by their primary care providers today. So when we talk about changing prior authorizations for the sake of the physicians, it really does obfuscate from the fact that we have a tremendous provider shortage in this state. And so every 15 minutes I'm spending doing prior authorizations is 15 minutes of my not seeing a patient. And every patient I don't see results in some of them going to the emergency room. And the emergency rooms are overflowing because, again, we have a provider shortage. And so I think it is appropriate to make some moves to actually reform care now and continue to study, because there are some obvious impacts. I've brought my patient along with me today to just talk about how devastating prior authorizations are and how we really cannot delay getting going on making simple changes that will reduce the burden on providers. And maybe we keep some of the older doctors in business longer, because prior authorizations are the largest cause of burnout. Prior authorizations hurt patients.
Okay.
They should be limited to far, far more than they are now. Oh, and all of this electronic reporting, somebody needs to be in charge of making sure the quality of those tools is adequate. But I'm glad we get to leave on Jonathan, because he'll tell you about how awful our struggle has been just to get him appropriate equipment for the last 3 years. Thank you.
Thank you. Next, we have Jonathan Opie on Zoom.
Yes. Aloha, everyone. And again, Chair, Vice Chair, thank you for your time. As Dr. Smith alluded, the journey has been long and arduous, in excess of over 2 years now, trying to get an electric wheelchair. For various reasons, denial comes back time after time after time. I don't want to belabor the point because it's so dire, and I don't want to take up your time because I'm sure there are other things that you need to discuss and other people may want to have something to say. But I want to leave you with this. I'm running out of time. My legs are going. Ambulatory movements are way more difficult now. I was diagnosed with MS in 98 and have been struggling with it ever since. The next time you bump your funny bone on your elbow, I hope this thought comes to mind. I don't have one on my right arm. A year ago, I fell and knocked the chip of that bone up into my tricep, and it never healed properly. So as I said, I'm running out of time. Prior authorizations, yes, they do work, but they delay, doesn't help the process. Whatever you can do, whatever we can do together to mitigate this process and get people the equipment that they need for a life-changing experience, there's no question, we have to do this. Again, I implore you to look into this and understand that for some of us, this is dire. We are running out of time. Again, from the Big Island, much aloha. Thank you for your time. And truly, again, thank you. Aloha.
Thank you so much for your testimony. That's all I have registered to testify on this measure. Is there anyone else wishing to testify? Seeing none, members, any questions? Oh, go ahead, Rep. Martin.
I have a question for Dr. Lewin. How HMSA had suggested that the more appropriate place to report the statistics to would be the insurance commissioner. Do you agree with that?
I think that there are 3 bills that have asked it to come to SHPTA this time. We think we have the time and perspective to do that. There are some really pressing issues regarding housing and insurance and so forth on the insurance commissioner. So we think that we really have the time to pull this together and to work with all the parties to make it happen. And it really has to be all of us together to do this, or it won't work. As we stated, this isn't a mandatory thing in statute. This is saying we're going to come together and collaborate and see if we can't agree on what the standards are and then allow that to be automated. So we think it's doable, and we know it's sensitive for everybody. This is tough for the insurance companies as well as it is for doctors and hospitals. But we think this problem can be solved, and Hawaii is the place to do it. We're ready to go. Thank you.
Thank you very much. I have a question also, if it's okay, Chair. Vice Chair. For the Hawaii Academy of Family Physicians, is that you? No, that's or HMA? Do we have anyone here?
Oh, yeah, HMA. Dr.
Aloha.
Ignacio? Oh, yeah.
Yes, hi, Dr. Ignacio. I'm here if I.
Yeah, so in your testimony, you were concerned, there was some language that was put in by the health chair in the last committee about the turnaround time, and that included a requirement for the healthcare facility to respond to questions within a certain time frame, or else have to submit a new prior authorization. And your
Yes.
testimony suggested that that might be counterproductive, and you suggested a turnaround time of 2 weeks, was it?
2 weeks to respond with additional information that's requested.
Yeah.
Yes, Representative.
So you think that would be appropriate?
Well, according to our colleagues in our Public Policy Committee, and we confer to a lot of our colleagues about what happens with prior auth, and there's great heterogeneity and some inconsistency with how the payers handle the need for additional information. But in general, they usually, the provider is given at least 2 weeks to respond, because it can take up to a week to know that it's been denied. So, or even having a question of medical necessity. So if we need to respond with additional information, acquire more information from the patient or from others, the specialties or whatever, we would like to have the normal amount of time that we've had in the past to respond with additional information to the payers. So 2 weeks is usually the standard that a lot of my colleagues get to respond once there's a question of medical necessity.
Thank you very much. Thank you, Chair.
Thank you.
Thank you. Members, are there any other questions? Seeing none, we're going to take a short recess.
Yep, recess. Reconvening, members, we have a number of items on the agenda. First up, we have HB 496 HD1 relating to Mamaki tea. Chair's recommendation is to add 1 FTE per the Department of Ag's testimony for 1 inspector. and to add an appropriation, blank appropriation for that. Members, any comments? Vice Chair for the vote.
Members, voting on House Bill 496, House Draft 1. Chair's recommendation is to pass with amendments. Chair and Vice Chair will vote aye. Representative Iligan.
Aye.
Representative Ichiyama.
Aye.
Representative Iwamoto.
Aye.
Representative Kong.
Aye.
Representative Lowen.
Aye.
Representative Martin.
Aye.
Representative Tam.
Aye.
Representative Pierick. Chair, your recommendation is adopted.
Thank you, members, and thank you for bearing with the longer hearing that we had today. Next up, we have HB 978 HD1 relating to electric utilities. Chair's recommendation is to pass as is. Members, any comments? If not, Vice Chair for the vote.
Members, voting on House Bill 978, House Draft 1. Chair's recommendation is to pass unamended. Knowing the presence of all members, are there any members who wish to vote no? Any reservations? Seeing none, Chair, your recommendation is adopted.
Thank you, members. Next up, HB 1316 HD1 relating to the Department of Land and Natural Resources. We need to make a couple technical amendments in here, and I'd like to amend it so that the registration fees go to the State Park Special Fund under Chapter 184. Members, any comments? Vice Chair for the vote.
Members, voting on House Bill 1316, House Draft 1. Chair's recommendation is to pass with amendments, noting the presence of all members. Are there any members who wish to vote no? Any other noes? Any reservations? Seeing none, Chair, your recommendation is adopted.
Moving on to HB 914 HD1 relating to water carriers. Chair's recommendation is to blank the index and include in the committee report that the next committee should consider any alternative indexes to peg this to. I want to change shall to may for the PUC's consideration in page 1, line 6, and anywhere else that's applicable to. I also want to note in the committee report that this is already under consideration by the PUC and this bill may not be needed. Members, any comments? Not, Vice Chair for the vote.
Members, voting on House Bill 914, House Draft 1. Chair's recommendation is to pass with amendments, noting the presence of all members. Are there any members who wish to vote no? Any reservations? Seeing none, Chair, your recommendation is adopted.
Thank you, members. Next up, HB 1161 HD1 relating to transportation. I'd like to adopt the amendments of the Insurance Commissioner and DOT. I also want to add that DOT needs to add plug-in hybrids to this program, but I am going to give them until July 1st, 2026 per the DOT's request to implement that. So we'll give them about a year more. Members, any comments? Not, Vice Chair for the vote.
Members, voting on House Bill 1161, House Draft 1. Chair's recommendation is to pass with amendments, noting the presence of all members. Are there any members who wish to vote no? Any other noes? Any reservations? Seeing none, Chair, your recommendation is adopted.
Next up, HB 1301 HD1 relating to transportation. We'll be deferring this measure. Chair notes that under HRS 431, Article 10C, Section 703, this already requires TNCs to provide insurance coverage for drivers while they are engaged in work with them. Moving on to HB 624 HD1 relating to school psychologists. Chair's recommendation is to pass this as is. Members, any comments? Vice Chair for the vote.
Members, voting on House Bill 624, House Draft 1. Chair's recommendation is to pass unamended, noting the presence of all members. Are there any members who wish to vote no? Any reservations? Seeing none, Chair, your recommendation is adopted.
Moving on to HB 815 HD1 relating to health insurance. Chair's recommendation is to pass this measure as is. Members, any comments? Seeing none, Vice Chair for the vote.
Members, voting on House Bill 815, House Draft 1. Chair's recommendation is to pass unamended, noting the presence of all members. Are there any members who wish to vote no? Any reservations? Seeing none, Chair, your recommendation is adopted.
Moving on to HB 463 HD1 relating to eviction records. Chair's recommendation is to adopt amendments from the judiciary. I'm also going to note in the committee report the disassociation idea, but that it needs further testimony to determine if it's practical or feasible to implement by the judiciary. Members, any comments? Vice Chair for the vote.
Members, voting on House Bill 463, House Draft 1. Chair's recommendation is to pass with amendments, noting the presence of all members. Are there any members who wish to vote no? Any reservations? Okay. Reservations for Kong and a no for Pierick. Any other noes or reservations? Seeing none, Chair, your recommendation is adopted.
Moving on to HB 467 HD1 relating to foreclosures. Chair's recommendation is to pass this measure as is. Members, any comments? Seeing none, Vice Chair for the vote.
Members voting on House Bill 467, House Draft 1, Chair's recommendation to pass unamended. Noting the presence of all members, are there any members who wish to vote no? Any reservations? Seeing none, Chair, your recommendation is adopted.
Moving on to HB 1325 HD1 relating to housing. Chair's recommendation is to add language similar to the proposed Amendment 2 from the Medical Legal Partnership for Children in Hawaii, which creates creating enforcement abilities against non-compliant developers. Members, any comments? Seeing none, Vice Chair for the vote.
Members voting on House Bill 1325, House Draft 1, Chair's recommendation is to pass with amendments, noting the presence of all members. Are there any members who wish to vote no? Any reservations? Seeing none, Chair, your recommendation is adopted.
Moving on to HB 553 HD1 relating to insurance. We will be deferring this measure. Vice Chair will be introducing a concurrent resolution to make this into a study. Moving on to HB 557 HD1 relating to telehealth. We will be adopting the DOH amendment to extend the sunset date by 1 year instead and revising this bill and revisiting this bill next session, given the federal uncertainty. Members, any comments? Vice Chair for the vote.
Members voting on House Bill 557, House Draft 1, Chair's recommendation is to pass with amendments, noting the presence of all members. Are there any members who wish to vote no? Any reservations? Seeing none, Chair, your recommendation is adopted.
Moving on to HB 712 HD1 relating to health. Chair's recommendation is to pass this measure as is. Members, any comments? Vice Chair for the vote.
Members voting on House Bill 712, House Draft 1, Chair's recommendation is to pass unamended, noting the presence of all members. Are there any members who wish to vote no? Any reservations? Seeing none, Chair, your recommendation is adopted.
Moving on to HB 250 HD1 relating to health. Chair's recommendation is to adopt SHPTA's proposed amendment for the group composition, also to adopt HMA's amendment to change it to 2 weeks. And I wanted to also note that this is already a working group, not a commission. Members, any comments? Seeing none, Vice Chair for the vote.
Members voting on House Bill 250, House Draft 1, Chair's recommendation is to pass with amendments, noting the presence of all members. Are there any members who wish to vote no? Any reservations? Seeing none, Chair, your recommendation is adopted.
Thank you, members. Moving on to HB 807 relating to condominiums. Chair's recommendation is to amend the language to clarify the term community development financial institution, to insert that throughout. Also to add to Section 6 the requirement that a condo must have received at least one letter from a financial institution declining its eligibility for a loan to address maintenance and/or insurance coverage issues, and also to have obtained full replacement coverage, insurance coverage, or intends to do so as a condition to any financing received. Members, any comments? Seeing none, Vice Chair for the vote.
Members voting on House Bill 807, Chair's recommendation is to pass with amendments, noting the presence of all members. Are there any members who wish to vote no? Any reservations? Seeing none, Chair, your recommendation is adopted.
Moving on to HB 1047 relating to interest on insurance proceeds related to a mortgage loan. Chair's recommendation is to amend subsection A by adding that in the event of a state of emergency declared by the governor pursuant to HRS 127A-14, also amending on page 3, subsection 2, by deleting language that such an account must generate an interest rate that is not less than the national rate, deleting similar language on page 2, subsection 2, deleting language in subsection 3 on financial institutions charging the borrower a fee for maintenance or disbursement, and deleting similar language to that on page 12, subsection 3. Members, any comments?
Just a quick disclosure.
Yep, please.
I'm credentialed with multiple insurance companies as a provider. Just a disclosure.
Oh, sorry, what was that?
Just a disclosure that I think I'm connected to this bill by being credentialed by insurance companies as a provider.
Okay, you can rule on that on the conflict on the floor too if you need.
Okay.
Okay, thank you. Vice Chair for the vote.
Right, members voting on House Bill 1047, Chair's recommendation is to pass with amendments, noting the presence of all members. Are there any members who wish to vote no? Any reservations? Seeing none, Chair, your recommendation is adopted.
Thank you, members. We are adjourned.